So I want to thank, we have an outstanding panel of reporters who cover court and legal issues and have covered the court, either are covering it now or have covered it in the past. It's 11 o'clock right now. We have them until noon. And each of them is going to talk about a different aspect of court coverage, and then we'll have time for Q&A. Our panelists are Lydia Wheeler. She's an award-winning senior reporter at Bloomberg Law, where she covers legal issues and litigation involving healthcare and employee benefits. She's written extensively about some of the country's most controversial cases, including constitutional challenges to Obamacare and state bans on same-sex marriage. Then we will have Todd Ruger, a senior legal affairs staff writer at CQ and Roll Call, who covers the Supreme Court, Congress, and the Justice Department. He's covered 4 Supreme Court confirmation battles and wrote about the Supreme Court's 2017-18 term in his book, American Justice 2018, The Shifting Supreme Court. Then we have Christian Farias, a founding editor of Inquest and a senior law fellow at Harvard Law School's Institute to End Mass Incarceration. In his years as a legal journalist and columnist, he's written about law and justice issues for the New York Times editorial board, as well as for New York Magazine, Vanity Fair, GQ, The Atlantic, Slate, The New Yorker, and other outlets. And then finally, we will have Chris Geithner, who's a journalist for MSNBC, an MSNBC columnist who's been writing about legal issues for the past 2 decades. His work includes widely recognized coverage of LGBTQ issues, the criminal legal justice system, and other complex legal and political questions. I'm going to start with Lydia, who's going to talk about some of the basics of covering the court, everything from hard passes and soft passes to getting transcripts, getting audio recordings, identifying justices, filing pressure on busy court days, and so forth. Todd is going to talk about finding stories outside of the typical case stories, the trends in politics and nomination fights. Christian will talk about how to cover the court as an outsider, somebody who comes in and covers a case or two as opposed to on an ongoing basis. And then Chris is going to talk about the shadow docket and other ways the court is making news outside of its main cases. And with that, I will turn it over to Lydia. All of you, thank you very much for coming. And Lydia, let's hear from you first.
Oh, great. Well, thank you so much for having me, and happy first day of the new term. My day started off like a lot of Supreme Court reporters, a lot of court reporters' day, waiting for the 9:30 orders list to be released. That is the list of cases that the justices agree or refuse to hear this term. The Supreme Court has like a schedule of events that they pretty closely adhere to, and you'll need to know like kind of what they're doing when, because that's when the most news happens. So typically on Fridays, they meet behind closed doors and have what they call a court conference, and they get together and they decide, what cases they're going to take and which they're going to reject each term. And they get like anywhere from 7,000 to 8,000 petitions. But they only hear a very small portion of that. About 80 cases is what actually make it to the oral argument. So the orders list, a lot of times we'll get on a Friday afternoon a list of cases that they've agreed to take. And then Monday is typically the day that we get a list of those that they've rejected. I will say that, both make news. The cases that they hear and the cases that they don't hear are fodder for stories. Because if they decide not to take a case, then that means the lower court's decision stands. It's also significant that they're choosing not to hear a certain issue. And so there's a lot. There's like, I think today's orders list was 60 something pages long. And so, you'll have several stories kind of all at once that are, you're getting news. It's and so it's like, well, how do you write that many stories all at once? And then also arguments start at 10. So if you have to cover arguments right after that, you have to run from one to the other. That is where pre-writes come in very handy. So, kind of a trick that Supreme Court reporters use is we prep all our stuff ahead of time. So today I was following 3 separate cases about healthcare issues, and I had pre-writes for all of them with different leads based on if the court took the case or rejected the case. And then I could just kind of hit the, delete which top is the wrong one, keep the right one, and then ship it off to my editor so they can quickly hit publish. So that's what we do there. And, this is important because, you have to kind of, if you're in the courtroom, you have to publish what you need from orders and then go upstairs and sit in the Supreme Court. And now I'm someone who I never had a hard pass for the Supreme Court. There's two types of reporters that cover the court. There's those that have what they call hard passes. They apply for a specific press pass with the Supreme Court. That gives them preferred seating up in the courtroom. Kind of they get to go into the arguments a little later than the rest of us have to kind of file up and file in line. And like I said, you have to apply for a hard pass. The Supreme Court has, its own its own process for how they decide who gets one and who doesn't. It has to deal with what outlet you work for, seniority. When I was at the Hill, I had been covering the court for a couple years, and I was just about ready to apply for that hard pass when I actually moved over to Bloomberg Law. So I never had the joy of having a hard pass holder and getting to sit in the good seats, is what we call them. A little bit about the way that the Supreme Court is set up is you line up for arguments and you go up the stairs and you have to go through security. You can't have your phone with you. You can't have anything other than a pen and a piece of paper. Christian will have to tell you how he accidentally snuck a cell phone. I think it was 2 cell phones into the courtroom. Yeah, you get in big trouble for that. And so you go in and it's, like I said, the hard pass holders have these benches that have cushions on them. And they're kind of in the front of the courtroom. So they get the best view of the justices. The rest of us come in and we file in between these little side alcoves. And there's these big curtains and huge pillars that drape down in between each one. And you kind of you fill into those chairs. But if it's a really big case where all these reporters are kind of parachuting in for the day to cover that court or that case, there's these line of chairs behind those alcoves. And based on the seating, there's only 3 chairs that actually give you any sort of a view of the justices. So I'll never forget one of my first big cases. I had no idea that many people would be showing up. And I also had no idea that they were going to line up chairs. And I got I think my chair was E13 or something like that. I had absolutely no view. And I was like, how am I going to tell who is talking at all? And so something kind of I wish I had been told ahead of time is that, no, you won't always see the justices, but it's good to have them memorized and be able to recognize them by their voices only. So I think right after that right after that, the argument day, I went home. I was like, I'm going to pull up old transcripts of cases and match them to the oral argument, the recordings. And I just sat and listened, and read through the transcript and I was like, okay, this one has a little bit of an accent. This one, so you could recognize, because it wouldn't be my last time not being able to see them. There's been lots of times. And so that gets, stressful on a busy court day because you're already nervous and all you have are your notes. And, luckily, there's some camaraderie, the reporters will be like, oh, that's Kennedy, or, oh, that's, what Kennedy was on the bench. But, so we kind of help each other out a little bit, but there is nobody standing there with a sign. I guess there used to be somebody that stood there with a sign to tell you who's talking, but not anymore. So I recommend getting to know the justices by their voice. Yeah, and then, kind of after arguments, that's when we all kind of race down the stairs and you have to go file. And that's another time where pre-writes come in really handy. You don't want to spend your time, formalizing your story and writing the background of the case. That wastes a lot of time because you're not going to get a transcript of the arguments until about 90 minutes after the arguments end. And so for a lot of us, the pressures of writing for the web is that your editor wants that story kind of immediately. And editors don't, it doesn't matter how many times I told them, I can't bring my phone into the courtroom with me. It kind of never failed. I'd show up back up at my desk and, they know that the argument lasts 60 minutes and I'd have a phone call that's like, where's your story? So I'm like, I got to type it out. But that's why background graphs of explaining the cases are really important. And then kind of how we cover arguments is you want to get a sense of where the court might be leaning. And so that's kind of always hard to predict. So you have to watch really what justices have asked questions. They ask questions that are tough on both sides, but your whole goal as kind of a reporter is to walk away and kind of, shine a little bit of a crystal ball on arguments of the justices appeared to be, leaning towards this side or appear to be, hesitant about this issue. And so sometimes that's easier to do than other times. I think there's been times I've walked out of the courtroom and I'm like, I have no idea where they're going to go with this one, and that's okay too. And so that's one of the pressures of that. But yeah, about 90 minutes after arguments, you'll get the transcript. And it, like, something that I learned kind of later on is that if you go into the press room and you say, hey, can you add me to the list of the early transcript, you kind of get it before it hits the website. So the court's press officers are definitely your friends. And when you don't have a hard pass, you kind of really have to know what you're looking for, and ask them to add you to email notifications for really important lists for when something drops. I think some of the hard pass holders get email notifications that kind of the rest of us don't get. So I kind of was one of those people always popping my head into the press office and chatting with the press officers and saying, can you add me to this list? Can you add me to that list? So they're your friends. Be nice to them and you will get more information. But yeah, that's kind of so far. I think I've hit like 10 minutes if you want to.
Okay. All right. So thank you very much. Let me ask one question and
Sure.
and then we'll move on to Todd. What's the most number of pre-writes you've done for a day? Like what's the busiest court day that you can remember?
It's the decision days, because you don't know what's going to happen on any given day. Like, we don't know what decisions we're getting when. And so we keep like a list, and you start really early with having all those pre-writes kind of ready for, June is the premiere. So really it starts in May. But I would show up to court and I would have all those files ready to go. And then, the end of the term is also when we're watching for Supreme Court retirements. So you had to have that pre-write ready to go too. And, there's always speculation about who's going to be retiring that year. But, sometimes there's wild cards. So I think I had a pre-write for Clarence Thomas. Like I had that years ago. Clearly he hasn't retired. He's still there. But yeah, you have to have all of that ready as well. And that was an interesting thing too. I remember the day that Kennedy announced his retirement, they had gavelled out the Supreme Court term. And they, there was no announcements. And my editor was like, I want you to write a story about how he didn't retire. And I was like, no. Like it could come later. The day's not over. Sometimes this gets announced hours later. Sometimes it's a couple days later. I said, I don't want to write that story that says like, he's like gaveling out the term, and that he hasn't retired if like, we're going to get it later. But, so this is where sometimes being there in person is helpful, especially being in the press room is helpful. I decided that day not to leave. I just decided to hang out in the press room and work the rest of the day from a desk in there. And kind of everybody else had like kind of left, and there was just the hard pass holders who have actual desks there. And I'll never forget, it was like 2 o'clock or 2:30 or 3 o'clock or whatever. All of a sudden, the press officers come running out of their office with these papers, like actual just like pieces of paper that they start throwing at everybody. And that was how it was announced. And so I got that paper, and that showed up in my hand before it ever hit the website. And I remember I got on GChat and I said to my editor, I was like, this is not a drill. He's announced it. He's retired, push publish. But I had a very extensive rewrite ahead of time. So we had a very lengthy story. But I remember listening to some of the other reporters in the press room, and there was one reporter that was like, pick up the phone. Like it's like he's trying to call his editor. And he wasn't getting anybody. So that's where GChat, sometimes if you can get your editor to chat with you, alert them that this is happening, that's really helpful. So we were able to like hit publish immediately. So sometimes being there in person helps, because you get things faster.
All right. So now let's turn to Todd. So Todd, who I will note for the record that last week he ran in the Capitol Hill 5K and beat Justice Kavanaugh, which I guess he's the fastest justice. So congratulations on that.
Thank you. Yeah, he's the only justice that runs in it. There's some other judges, but that's my goal every year. I beat him this year, and it turns out the next day he tested positive for COVID. So I might have had a little help, but I do believe I retained my regained my title of fastest member of the Supreme Court press corps in that race. So anybody wants to challenge me, come to the ACLI challenge next. I think it's going to be in May. All
right. So I've had asked Todd to come talk about coverage of finding stories and coverage that goes beyond the case of the week or case of the term stories. And so I'll turn it over to you now, Todd.
Oh, thanks. And thanks for having me. I love this topic. Special shout out to Caroline Simon, CQ roll call team, immigration reporter. There are 0 court cases about immigration. There's just not much action. Oh wait, no, it's a million. So I think that touches on if you're covering policy, if you're covering politics, almost all of it's going to end up in the court these days. I mean, Congress is deadlocked. So you need to know this stuff, Supreme Court and down. It's going to really help you. When I got to DC, a guy named Tony Morrow, who is a legend of the Supreme Court press corps, he worked at USA Today, National Law Journal. He told me there's a good story behind every SCOTUS case. And I see his point. I think he told me that because I thought some cases were pretty boring. But it's exceedingly rare for a case to make the Supreme Court. There's, as Lydia said, there's only about 80. And it's a tough beat because there's not much breaking news in terms of stuff that's unplanned. You have a pre-write for everything, you know when stuff's going to happen. And what the court gives you is really limited. There's no FOIA. You can't public records request the court. It's largely limited to just what's on the docket. Every case has a docket. It's a list of all the filings in the case. There's a really competitive, solid core of reporters that cover these cases. And it's even harder now because the arguments are online. During COVID anyway, the electronic docket means everybody can play. News and analysis is like instantaneous on Twitter. So what you have to do to set yourself apart is come up with enterprise stories. These are stories that aren't just like, they did this, they did that, the Supreme Court did this. These are just off-speed pitches. These are little curveballs that are just off the beaten path that can turn into a story that separates your coverage from other people's coverage. And the best example of this is from last year. We had a Pulitzer Prize off of the Supreme Court beat. Andrew Chung, Lawrence Hurley from Reuters. They wrote about qualified immunity, which is a legally created way that police can escape accountability and for misdeeds. And that just happened to be a hot topic over the last couple of years. But it's a great lesson in how to do it, because what they did in talking to them, there were these qualified immunity cases appearing at the court. Sonia Sotomayor writes these dissents, and they say, how often is this happening across the court and across the country, and in what ways is it happening? And they went out and they quantified it, and they ended up having a great story, and that's kind of how you can do it. So how do you find these? It's just like any other beat. You find the information here. It's all begins and ends with the docket a lot of times. And the docket, every case has an electronic docket now that lists all of the documents. And there's tons of entry points, right? There's the parties in the case. There's the attorneys handling the case. There's all of the briefs that were filed in the case. Those are filed by law professors, members of Congress, former judges, nonprofit groups, cities, states, the United States. I mean, there's all those people have issues. All those people have side issues. There's arguments in every case, and there's other arguments in the case. There's multiple arguments. So what you need to do, I think there's two ways to do this. You take a thread, and you find these, an argument, a side argument, and you pull that thread and you see what happens. You zoom in, you say, okay, what if I just focus on this, the history, the person doing it, anything that's of interest that you find about this small little thing, to sort of zoom in on it. And there's another way to do it, which is to put it in context. So you take this argument and you zoom out and you say, okay, where does this fit in a greater scheme of things? Where does this case fit? How is it playing in Congress? Is there any legislation on it? That's the sort of stuff I look at anyway. And then you can also look at outside the docket, you can look at outside players, which are like, outside the court itself. One story I did was about whether the justices requested traveling with security. And for that, I leaned on this group called Fix the Court. They had filed a lawsuit with the United States Marshal Service, which is where the justices ask for protection on their trips. It was related to Justice Scalia's death in Texas and whether he was under protection at the time. But there's outside people who are sort of gurus about the court that you can follow and get information from. Once you get something, like I think one of the things it's tough to do on the court is to know what you're looking for. And I cover Congress basically for CQ Roll Call. We focus on Congress. So I have a built-in angle to a lot of this stuff, which really helps. But there's a couple overriding themes that I like to do, which is one of them is to explain, right? And so instead of just saying what happened, you take it and you explain. One story in 2017, There was a case about partisan gerrymandering, which is how they carve up states into congressional districts and get a skew it for a political advantage. And there was a piece of this, just this tiny little thing in this case called the efficiency gap. And it was a mathematical approach to determining how partisan these districts were. And so I teamed up with a data guy from CQ Roll Call named Randy Leonard. And we said, what happens if we push this out to all 50 states? What happens if the Supreme Court says, yes, efficiency gap, we like that. And what we found was that 8 Republican-held seats would be poised to flip to Democratic seats if they, under this efficiency gap standard, if it was applied. And so what we did is we took just this tiny piece, zoomed out, and then said, what would be the context? What would be the fallout from this case? Another thing that I like to do is clear the air. I mean, I don't know if you've noticed, but in DC, everybody's spinning everything all the time. So I like to write stories that clear the air. One of those that I did, Justice Amy Coney Barrett is going through her confirmation process, and the focus of Democrats was Obamacare. There was a case where the Trump administration wanted to wipe out, the Trump administration and Republican-led states wanted to wipe out this 2010 healthcare law. And what we ended up writing was, what I wrote was, that would cut against the court's traditional legal approach. It would conflict with decisions from the last term. It would defy the current reality about how the law works. And there's, basically, I'm clearing the air, like, it's probably not going to happen. What ended up happening, it didn't happen. So, and then I think one for a highlight of how to think through a lot of this stuff, there's a case today. I just looked at today's case. It was the first argument of the term. It was about a dispute over water between Mississippi and Tennessee. And Memphis is taking too much, according to Mississippi. Mississippi wants them to stop. Now, that is not a case that I would typically care about. Battle between states doesn't really do much with Congress. But I decided I'll look at the docket this morning and see what ideas could we spin out of that. So there's some interesting wrinkles, right? The United States filed a brief. So what is the nation's interest in this? And that could be its own story. Colorado and other states filed a brief. Well, why do these other states care? Like, what's at stake here? And if you're at the Denver Post, great, you got a story because Colorado's involved. The New York City Bar Association filed something. And I'm like, what do they care about water rights in Mississippi? Well, they say the Supreme Court should look to international law to solve these water disputes. And I'm like, whoa, where's that coming from? That could be a story, and then you back up even more. You're like, well, what does that mean? Maybe this is a bigger story in terms of climate change. When water becomes more scarce, what's going to happen to these fights between states? Colorado, clearly the Colorado River, Nevada, all of that stuff. So you can find just like that's 5 minutes of spinning off of the docket, what you might be able to do. So I think that would probably wrap it up for me.
Okay. So thank you very much. So let's turn to Christian right now, who's going to talk about coverage of the court when it's not your ongoing regular beat, when you're zooming in, parachuting into town to cover something. So Christian, I'll turn it over to you now.
Thank you, and thank you for having me. It's a pleasure to be here, and it's especially a pleasure to be here with Todd, with Lydia, and with Chris, because they are 3 people that I encounter most of the time that I've been at the Supreme Court. If anything, we would sit right next to each other because we were the quote unquote second tier reporters. We're not the hard pass holders who get all the special treatment. And the second tiers, we are, we just have this fellowship amongst each other. And so if I were to give you an advice, if you're covering the court for the first time, and I don't know when the court is going to open its doors, is look for these folks. They usually sit right in the middle aisle as soon as you get there. They're extremely affable, very knowledgeable, very friendly. All the other reporters kind of that sit in cubicles, they might not talk to you. Forget them, but do talk to the ones like Todd and like Lydia, who sit in that middle aisle, because they are the ones that, they kind of know their stuff and they're very friendly, and you need these helpers. Look for the helpers, as Mr. Rogers said. because the first time you're there, it can be very intimidating, and you don't know what the heck is happening, and this place is very kind of hollow and holy, and you know, you're afraid of your own shadow. But if you look for people like other reporters who sit in this special aisle, you should be okay. They'll be able to help you, as they helped me when I was new. And what was interesting about my case is that even though I was a Supreme Court beat reporter for quite a bit of time, I was an outsider in the sense that I'm not Washington based. I've always been New York or New Jersey based. And when I was hired by the Huffington Post, they told me, sure, yeah, you can cover the Supreme Court. You just have to travel every time whenever there's big cases. And all right, cool. So I will wake up at 3 in the morning, the day of an argument, hop on a train on the Acela or the Amtrak and get to Washington by 9 o'clock or 8:30. I don't recommend that. So if you cover the court, be in Washington is probably better, or come in a day or two before and plan your trip well. But as kind of an outsider, if you will, and not someone who is necessarily in this kind of beltway area of coverage of the court, I try to look at things and cases a little bit differently. And I always, or for the most part, I try to always kind of center the human voices of whom the cases affect. And the reality is that even though some of these cases are very wonky or very technical, I mean, even bankruptcy cases, ERISA cases, which Lydia probably knows a lot about, you know, they still affect real human beings, because when someone is complaining about their pension or the fact that it's not working the way it should, that affects real people. And they're going through hardship. And that's why they brought this case. Otherwise, you know, why are we here? And the reality is that most cases, even the more technical ones, they involve real parties with real problems. If there's someone suing the Consumer Financial Protection Bureau to blow it up, and that was a case we had last year, it was because there was this tiny little kind of shady law firm that was doing all these things. And you wonder, I want to know more about this law firm. And so don't ever be intimidated by the issue of a case. Just because it's very technical doesn't mean that there's a really interesting angle about either a party or the location. If you're local, Todd mentioned Denver, or whatever location you may be located in the future, just think of kind of, why do people in your locality just care about this issue, and interview local folks. That would be a far more interesting story than doing the same write-up that everybody is doing about the same case nationally. And at least for me, when I was preparing for the big cases, whether it was a Michigan affirmative action case, I would read the coverage from Michigan, honestly, because that's where the action first started. That's where the lawsuit began. And they have the most action, the best quotes. You have some scrappy figures and characters that rarely ever make it into the Supreme Court or the arguments that the justices deal with. Read up on the local coverage, and you're going to get tons of story ideas just from that. And as far as, you know, when I was just covering the court day in and day out, when the Supreme Court heard a big, the follow-up to the DACA case, it was called the DAPA case, D-A-P-A, in 2016. It was the big immigration case involving an Obama program. I teamed up with the immigration reporter at the Huffington Post, and we did this story on 3 mothers who were undocumented, whose children had citizenship status, and they were before the Supreme Court. Not a lot of people knew this, but they actually were formally before the court, and their lawyer was going to have 10 minutes of oral argument. And I was really curious about these 3 women, who they were, their background, why they were seeking the relief they were, how they came to the United States. And we got interview time. They're anonymous. Nobody knows what their names, due to, you know, because it's a very sensitive situation. But just to talk to them in Spanish and get to hear them and put their words in my story and why the case matters so much, I thought it made it far more interesting than a lot of stories around the DAPA case that were being written. Because again, the case was technical, everyone was writing about it, but we said, all right, let's talk about this party. These 3 women were a party to the case, and let us hear from them and see what they have to say and why, you know, their stake in the case matters so much. So that was interesting. And for the most part, as a legal affairs reporter at the time, I prized the knowledge of the education reporter, for example. I wrote a case about Gavin Grimm, the trans right, the trans student who was fighting to sue for bathroom access. And I teamed up with the education reporter because she had been covering the case. I knew the legal side of it. She knew the personal side of it. And Gavin was already a source. So it was a perfect way to kind of tell the story together. So always kind of look for people who know more than you. Don't be kind of shy to reach out to folks who may own a beat better than you. And if you're the court reporter and someone else is the criminal justice reporter or any other beat, just kind of work with them, and you'll be surprised at the kinds of stories that the two of you together can come up with as you research it. When the Supreme Court was hearing the citizenship question case involving the census, again, that was another case that everyone was writing about. Is a very complicated case about administrative law and about the Administrative Procedure Act, which, by the way, is my favorite federal law, in case you're wondering. But there was something in the case that not a lot of people were writing about, but it became a huge deal in June of 2019. And it had to do whether racist intent infected the citizenship question. And but again, not a lot of people focus on this because it was a very kind of technical thing that began at the very start when this case first began in 2017. It was something that the courts had considered, but then dismissed, and it never got to the Supreme Court. But then eventually this trove of documents were released. I won't bore you with the story, but just this trove of documents from this legal mastermind that kind of invented the idea of a citizenship question, who actually said it in very plain words that the reason for the citizenship question will give more power to white Americans and diminish the power of Latinos. And so based on that bombshell, I kind of wrote up this whole thing for the New Yorker on why that question matters, both legally, but also from a human perspective, because all of a sudden, this case wasn't this boring, dry administrative procedure case, but it became an equal protection constitutional case. And will the Supreme Court deal with it in those terms? Someone who is a Latino and who really looks to how the court answers these questions, that mattered to me, and that I was able to write about it was interesting. So always look out for kind of offbeat things that other people aren't looking to, and you'll be surprised at some of the things that you can come up with. And the third example that I have is when the coronavirus pandemic first hit last year, obviously the Supreme Court stopped having oral arguments, and nobody knew what was going to happen to some of the cases. But one of the big cases that I was watching, because I had attended the hearing months earlier, was the Docket case dealing with the Deferred Action for Childhood Arrivals program that Donald Trump had tried to end. And there was a big question as to whether our new definition for what essential workers mean, those food service providers, those frontline healthcare workers, those delivery drivers who bring our food home, who became truly essential at the start and even now during the pandemic, whether that would sway the court in a very human way. And the DACA litigants were very smart in that they filed stuff with the court after the case had been decided, after the case had been heard, but before the court had actually decided, kind of putting right in front of the justices the human toll that ending DACA would have on these frontline workers that are now basically helping to run America. Tens of thousands, hundreds of thousands of them who are DACA recipients, but who now are in extreme danger of being deported if the Supreme Court rules the wrong way. And the litigants use this kind of name and shame strategy to kind of get the court to do the right thing in a way. And some people might question whether that was a good strategy, but it looks like it worked because the court ruled in favor of the DACA recipients. But again, looking at the human side of how the Supreme Court's decisions affect real people, I think it's always it's something you can go wrong with, especially if you're writing for a general audience and for a publication that's not necessarily perhaps specialized. People want to hear about human stories, and the best way to get people interested in what you're covering is to just bring these human voices to the fore, and you can't go wrong with that. And that will be the end of my presentation.
All right, well, thank you very much. Great observations and tips. So now we will go to our fourth speaker, Chris Geithner, who is going to talk about the shadow docket, which our last speaker, Louis Seidman, mentioned. Chris, I want to welcome Chris and tell him happy birthday. I understand it was your birthday over the weekend, so happy birthday. And I'll turn it over to you right now.
Thanks a lot. Sorry I'm late, everybody. Believe it or not, I had 2 overnight fire alarms. So I was down on the front street at 5 and 6 a.m. this morning. So that was delightful. However, I'm here to talk about the shadow docket. So part of the shadow docket is that it happens at night. So oftentimes I'm actually have been up at night dealing with the Supreme Court shadow docket. So what we wanted to, I had looked at what Lydia and Christian and Todd were talking about and wanted to look at what was left and thought it would be interesting in light of where we have been with the court recently, and another key area that I think is often a place where you can get lots of stories. It's often a way into the court for people is the emergency docket that's been called the shadow docket. And so first, just what is that? It's technically any of the non-merits cases. It's things that come to the court that aren't what you normally think of, the things that we've been talking about, the cases that the court grants to hear full briefing on, to hear argument. You have all of these amicus briefs around it. What the emergency docket is everything that happens outside of that. Some of the most common case issues that technically come out of that are like cert being denied in cases, announcements that there's going to be split argument, announcements that the court can call for the views of the Solicitor General. So they basically ask the United States, like, could you tell us what you think about this topic? But where we've mainly been getting the discussion of the shadow docket about that emergency docket is basically using what Steve Vladeck recently testified before Congress about the shadow docket, and he sort of puts it into 4 categories, and it's basically asking the court to issue a stay, to vacate a stay, to issue an injunction, or vacate an injunction. And while those are 4 different things for lawyers, they're basically just one thing for people, well, 2 things for readers, for people who are affected by cases. It's basically either is the Supreme Court going to stop a lower court order from going into effect while appeals are happening, or is the Supreme Court going to make its own order that's going to apply while a case is going forward? And those, most often, in the way that it's easiest to think about it traditionally, is that would often be the case with executions. That's what before the past 4 or 5 years, what you would generally think of when you're thinking about the shadow docket. It would be those last minute requests for a stay of execution that the court would hear. And those have been coming for decades. But then over the past 5 or 6 years, the numbers have just continued to expand, and we've gotten more and more types of cases. The first area where this really did, where it seemed like there was more of a use of the shadow docket for some for some intentional purpose that became newsworthy was in the marriage cases. As the issue of whether same-sex marriage bans were constitutional were going through the court, oftentimes those cases would actually reach the justices before they reached the Supreme Court, before they held the full merits decision. And what would happen is a lower court would rule that the marriage ban in, say, Utah was unconstitutional, as happened with Judge Robert Shelby. And then that judge decided that he was not going to issue a stay. He was going to allow his ruling to go into effect while the case was being appealed by the state of Utah. What that meant is that Utah same-sex couples were able to get married immediately. That went up to the 10th Circuit Court of Appeals, which also said, we're going to allow that to continue. We're not going to issue a stay. That went up to the Supreme Court. And a couple of weeks later, the Supreme Court said, hold on, we're going to issue a stay while this is going up on appeal, because this is obviously a big constitutional question being decided. And that continued over the course of the marriage cases and eventually went the other direction. It went the other direction where the Supreme Court basically started saying, if a lower court has decided that that marriage ban is unconstitutional, there's not going to be a stay. You're going to be allowed to get married while that is while the appeal is being held. And that ultimately made a big difference when we got to the end of the road with Obergefell being decided in June of 2015. You ended up having, instead of only having like 19 states that had marriage equality, you ended up having 38 states where same-sex couples were already able to marry. And a lot of that came through the shadow docket decisions, the decision not to hold hearings on a case and to allow lower court rulings to stand, the decision to allow a stay to remain in effect, the decision to lift a stay in some states. And so we had that. And so there started to be a little more talk of the shadow docket. But then the Trump administration happened. And as Steve Vladeck talks about in his testimony, there were 41 requests from emergency relief from the Trump administration. There had been a total of 8 requests for emergency relief in both the Bush and Obama administrations combined, 8 total. And there were 41 in the Obama administration. And so that just like dramatically upped the number of times we had emergency requests at the Supreme Court in the travel ban cases. We had emergency requests at the Supreme Court in the census case that Christian had been talking about. We had obviously a lot of emergency requests at the Supreme Court when the Trump administration wanted to and did successfully restart federal executions. And so all of them were happening as the Supreme Court's makeup was changing and as we were getting a more conservative batch of justices. And so we started to see different substantive rulings coming out of the shadow docket. And that led to a lot more criticism and led to a lot more attention being paid to the shadow docket, what it means. As we went into the end of the Trump administration and started getting the COVID cases coming to the court, a lot of those came up as emergency cases. And some of those were direct COVID cases. Some of them were more religious liberty, had to do with whether or not church worship was possible. And under this court, given what this court thinks of religious liberty issues, those seem to get a lot more attention from the justices, from the conservative justices. And we saw the sort of one of the biggest shadow docket rulings in recent years was a case out of California that in a Perkarium ruling, so for the court, we didn't know what justice wrote it. They basically announced this ruling that was going to cut back what California could do to limit how many people could be attending religious service and stuff like that. And they basically announced a new standard for how religious liberty claims were going to be looked at from the court. And that was done without any amicus briefs. So no friends of the court. You didn't have all of the people that Todd was talking about who you'd be able to like see their views. You weren't able to see what other states thought of it. You weren't able to see what the federal government, well, in this case, the federal government, you did know, but you didn't have oral arguments. You didn't have the long time for the justices to go back and forth with drafts of opinions and go back and forth among each other of like, okay, well, here's my draft dissent and you get to see it. And then like what ends up happening with regular merits opinions is they're able to sort of like you start seeing like fighting back and forth in footnotes sometimes in cases because they've had all this time to go back and forth. But that doesn't happen with the shadow docket because it can happen in 2 days, 3 days. And then when Biden took office, you had some more shadow docket cases. You had the eviction moratorium. And in that case, we had 2 different times that we had emergency petitions. In the first one, we had a really interesting situation where Justice Kavanaugh basically said, I'm going with you this time, even though I don't think this is allowed. And I'm going to allow you to keep it. But if you try to do it again, I'm going to vote against you. Which was really weird. That's not what happens. That's not how the court works. And so it was a lot of attention to how weird this shadow docket process is and how much of a lack of process it is. And so over the time since then, most infamously recently we had with Texas SB 8 when it came to the court on the shadow docket. In the days before this very limited ban, the most strict ban on abortion in the country was going to go into effect. It was before the justices, and all of us who have covered shadow docket things were waiting the night before it would go into effect because that's normally when you would get a ruling because there was basically a deadline. It wasn't an execution, but there was a law that was going into effect at midnight. And we never saw a ruling that night. And the law went into effect the next morning. And it wasn't until the next night that we got the ruling that we got. And we found out that there was a lot of controversy within the court. And Chief Justice Roberts joined the 3 liberals, but with a different reasoning. He basically said, we could have put this law on hold while we took up the case on the merits and decided whether this is constitutional or not. But he wasn't even able to get Justice Kavanaugh, who had like similarly sort of given some time in the eviction moratorium case to do it. And so all of that's to say that sort of a brief history of where the shadow docket has come from in the past 5 years and why it's getting so much attention, to the point that last Thursday, Justice Alito actually gave a full speech at Notre Dame, basically opposing the criticism of the shadow docket. And he gave 10 points that he sort of tried to offset. And some of them, as my Twitter thread, were like they sort of conflicted with each other in his answers. And it wasn't quite clear whether all of his reasoning was the most objective. But it is certainly something when something is getting enough attention that a justice is giving a speech to respond to that criticism, that definitely tells you that it's something that you as a reporter have the opportunity to find stories in. Any case that is going up to the court ahead of time. It's something that if you don't know the process, if you're not paying attention, you're not going to necessarily see it until the decisions come out, or the day after the decisions come out. So that's another time where, like, an advantage of following other Supreme Court reporters on Twitter or something will give you some insight into those things. And then if you see a case that you're following, just to be paying attention whether what they're called is applications, whether there's an application for a stay, an application for an injunction, an application to vacate a stay. And then to know that that's something that, as opposed to normal Supreme Court stuff that can take up to almost a year or more to go through the process, these applications can go through the process in as soon as 24 hours, but generally like in a week or two period. So that's what I've got.
All right, so we have time for some questions. If any fellows have a question, raise your hands. We'll go to Oma first and tell the panelists where you're from, and we'll go Oma and then Madison.
Hi, everyone. Thank you so much for being here. I'm Oma Sadiq. I'm a politics reporter at Business Insider. And I'm actually just starting out on the Supreme Court beat. So thank you for all the great info. But I wanted to ask each of you, what's one thing you wish you knew when you were starting out and getting familiarized with the Supreme Court and reporting on it? So yeah, what's your one thing that you wish you knew?
All four of you can take a crack at this one. We'll just go in order again. Lydia, Todd, Christian, and Chris.
Yeah, I think I wish I had known the process a little bit better. You know, kind of when you come in, I was brand new to it. You know, I was mentioning before that it has like this order that they adhere to this schedule of events, and paying really close attention and knowing when those things happen. And like, you know, Chris was just mentioning, like following cases that are in the lower courts and what could potentially be like some sort of application could be submitted to the court. You know, going into the press office and saying like, hey, can you add me to an email alert list for that? And they might say, oh, you know, we might not have this. And they always say like, check the docket first. That's where you get things first. And they're right. But like, you know, asking them to be on that alert, oftentimes the press office will send out an email to, you know, the press corps, at least the reporters who have asked and said, hey, this has been filed. And that's when you get the breaking news. And I didn't quite know, not having a hard pass, that was something that I could ask for. So like, you know, just getting in really well to know the press officers and getting them in to know you, and you know, being bold enough to ask for those alerts, and you know, staying on top of which cases to cover, I think was something that early on I wish I had known that was something I could do. And once I figured that out, it was like, oh, now I get where everyone's getting this news. But there were times early on at the beginning where I'm like, how did they find that? It's not even on the docket. I mean, like just the abortion case was like, there was a petition that took a week or something like that for it to finally show up on the court's website. So, you know, asking in advance from the press officers for that stuff, and if they can add you to any alerts that they're going to send out, is really helpful.
Okay.
I would say this probably might not apply to many of you, because when I went through journalism school, I thought after I graduated and I started working in the real world, I could have used some real good like secretary skills, you know, tracking cases, coming up with a way to make sure you're on top of everything, using your calendar. Super important to use your calendar. Just put something on your calendar, set it, reminder, come back to it, you know, whatever it is, because there's just so many cases and so many things moving up and down and so many oral arguments, especially if you're covering courts other than the Supreme Court as well. So I would say just sharpen up that non-journalism part of tracking.
Yeah, two quick, I guess, things that are not intuitive. I would suggest you print the Supreme Court calendar for the term. It has all these little color coding on it, because that a lot of people don't know that tells you, one, when opinions will be released, and when for most of the term. At the end of the term, things get crazy, but for most of the term, you know that those days might be opinion days, and those days the court hears cases, or if they're having a private conference. It's good to know, that sometimes it's nice to know that on a Wednesday, generally you're free. You don't have to worry about Supreme Court stuff because something's not going to come down. Again, at the end of the term, things change, but for most of the year, you're good. So yeah, keep tabs on that. And also remember this term, opinions relating to orders. It sounds very weird, but jot it down, opinions relating to orders. Because when you're wondering about where the hell is this latest thing that just came down that is not on the Supreme Court homepage, because the Supreme Court doesn't put everything on its homepage, you have to go digging for it. Just Google Supreme Court opinion relating to orders, and that'll take you to this little page that has all these detached opinions from the court on procedural orders that are a big deal. Also also Supreme Court orders, period. Google that for just general orders. Because again, that's not easy to find if you're just browsing around, but if you Google those things, you'll find them.
The big thing that I would say, and it's sort of been referenced in some things that other people have said, but it really does bear repeating, is the public information officers for the Supreme Court are your friend, and it's really important. When I started, like the first cases that I covered at the court, I was with Metro Weekly at the time. I had no idea what I was doing and was just like looking on the website and like trying to do the right thing. But like the truth is, like, the Supreme Court website is impenetrable for things like that, for things that you actually need in life. And so as a reporter, and so like just talking to them has just like made it over the course of, I've been like here for more than a decade now. And it like is to the point now that like, even when like, I'm just like part-time for like a columnist for MSNBC, but when I like email them and I'm like, can you add me to this list? They're like, absolutely. Because like I've established that relationship, and there's a lot of good and bad about that. Because it is sort of this idea that like the Supreme Court is this really insular world. And it is sort of like something that you have to like delve into in order to get into it. But if you are willing to do so, they really are willing to help make sure that you can do it.
I also had one more quick thing to add too, that's something I wish, and it seems silly, but brush up on your note-taking skills, because when traditionally we are in the courtroom, you can't have your phone, you're not recording. Like I said, transcript comes out 90 minutes after arguments. That's an eternity. So something I wish I had known early on is like, you're going to rely on your own notes. And there was times I ran back to the press room because I'm so nervous, and you're trying to, that I'm like, what the heck does that say again? And it happens. And so I actually had an editor that said, you should watch like the morning shows on Sunday morning and take notes while you're watching TV from home, sipping your coffee. It does wonders, because I was not taught shorthand in journalism school. So yeah, you formalize your own, but a lot of us run around Congress with our phones, and we can record, and we can, you record all your interviews, and you can't do that here. So I would say, make sure you have good note-taking skills.
All right, thanks for that. That'll help me in my class that I teach undergraduates. I don't let them use your laptops or recording devices in class, because I say it's important to learn how to take notes. And you've just given me another talking point on that. Madison.
Hi guys, my name is Madison Alder. I cover the judiciary for Bloomberg Law. I am curious what you make of these recent criticisms we've seen of Supreme Court coverage. Chris mentioned we heard from Louis Michael Seidman before today, and he mentioned that the media has helped perpetuate myths that the court is filled with kind of wise, high-minded individuals. What do you make of that recent criticism, and how can we hold justices accountable in our everyday coverage of the court and the judiciary?
Yeah, well, I think I'm obligated to mention you should follow Balls and Strikes, my friend and former coworker Jay Willis is the new head of that. It's a demand justice related project, and that is a publication that is just launched and is really focused on holding the court accountable. And I think we are seeing a lot more willingness to treat the justices and to treat the judiciary as something that we are not obligated somehow to cover it in a different way just because it is called a different branch of government, when it's very clear that there are overlapping political elements to those branches. And I think it's remembering your journalistic obligations to actually to report what you see, and not to report what you are told from textbooks is how we should be covering the judiciary as opposed to others, I think is the best way that I can think about it.
Yeah, I would add to that the justices are very much political actors. They like to pretend that they're not, that they are kind of above politics, that they kind of float above Washington, and that they wear these black robes because they don't wear the color of a party. But the reality is that they make highly controversial decisions that are highly political, and highly political cases that the whole nation really cares about. And they don't like when you name their party affiliation, but I think we owe it to the public to say that when 6 Republican appointed justices let an abortion law go into effect, that you just have, or 5 rather, that no, they're not overruling Roe v. Wade, but they're effectively preventing every woman in Texas from having an abortion. You just have to say it, because it's basically part of your journalistic duty to tell readers that, in case they don't know who the justices are, and things of that sort. And I would add too that the justices may not like that you are perhaps printing the party of the president that appointed them, but it's important to do it, because we need to demystify the court as this thing that is nonpartisan. The reality is that in 2000, the Supreme Court decided a presidential election. The reality is that in 2013, the Supreme Court allowed a law that was a bulwark of the civil rights movement to basically be a dead letter, and that allowed for voter suppression the very same day in many states that basically wanted to suppress the vote of minorities. And the Supreme Court has made a ton of decisions that are basically political decisions, from allowing money in politics to many other things. So to pretend that they are, not acting politically is simply not the case. So just be very clear-eyed about this history. Learn the history of these highly political, controversial decisions, especially when you're covering those cases that deal with politics and that have perhaps a partisan valence to them, because the justices will line up according to the president that appointed them.
Okay. Well, let's just, it's afternoon. I just have one final question. And I just like to hear very briefly thoughts from the 4 of you. And that's if a journalist wants to go on and, if they're one of their ambitions is to cover the court down the road, is there benefit in your eyes of getting a law degree? And is there benefit in your eyes of getting like one of these 1-year Master of Law degrees? Like I think Yale has one of those programs, and some others have those programs. As a tool for a journalist who wants to cover the Supreme Court long term, are those good things, worthwhile, or not so much? Let me just hear from the 4 of you. Lydia?
Well, I don't have a law degree, so I have maybe a unique perspective to this. I started covering the court because I was actually hired as a federal regulations reporter, and a lot of the rules, that agencies put out end up getting challenged, and those challenges would make them to the Supreme Court. And I just started liking that coverage, and so I started to kind of seek out those stories. And kind of I'm I learn as I go, and there are several, reporters at the Supreme Court that have law degrees. And I think I felt in the beginning that maybe I was, I had like, imposter syndrome, because it was like, oh, I'm not an attorney. I'm learning all this. But I actually had the nicest compliment, which is, another reporter came up to me who does have a law degree, and she says, I actually read your work to see kind of how you explain something in layman's terms. Because like you're used to putting that, she says, sometimes for me, as with someone who was a former attorney, it's hard for me to kind of like take out all that legalese. And so she's like, but you do a really great job of being concise. So for me, not having a law degree hasn't been a hindrance in any way. It can give you an additional leg up. Some outlets like that you have that sort of, pedigree. But I will say for me, it hasn't been, anything that has stood in my way. But yeah, if you can, if you have the money and you want to, I wouldn't say don't do it, but I think that you can be a successful court reporter without it, because like a lot of the same skills that you have as a journalist, you need, like they transfer over no matter what beat you're doing. And so, the law is always made out to seem like it's way more complex and mystified than it really is. And so don't be intimidated.
Okay, Todd.
My short answer is you absolutely do not need a law degree to cover the Supreme Court, and I would not undertake the debt required to do so. And I also probably wouldn't incur the debt required to take one of these one-year law degree things. I think if you cover the court for 1 year, you probably get a good enough education. And I think the most important skill is story conceptualization. How do you find and frame a story? And they don't teach you that in law school. You might need to round a few more bases in your reporting to make sure you're not going down some crazy wormhole of law, but you don't need one.
Okay, and Christian, who has one, what's your view?
I have a law degree, and I can tell you just very confidently, don't go to law school. You don't need a law degree to cover the court. I was not planning to become a legal journalist when I went to law school. I wanted to be a public defender or a civil rights lawyer. Journalism kind of found me in a way, because I was a journalist for many years before I went to law school. So, so I just kind of went back to that. But yeah, read my bio because it's weird. But I did not go to law school to cover legal issues, and you don't need it. The reality is that you can be a fine writer without ever stepping foot in a law school or opening a casebook or none of that sort. Just read good writing on the Supreme Court and legal issues, and you'll be all set. I believe Lyle Denniston, who is kind of the dean of the Supreme Court press corps, he's in his 90s, he's covered the court for like 60 years. I don't think he has a law degree, and his prose sings. Like, you never hear him say any legalese, use any legalese in his writing, which is really what you want. You want to make the Supreme Court as accessible to the public as possible. Okay,
and finally, Chris.
Yeah, basic, same. I mean, we're all in agreement. You absolutely. I had a law degree. Same as Christian. I definitely did not go to law school to be a legal journalist. I practiced for a few years, and are there times when I am glad that I went to law school? When I delve into a case, sure, every once in a while. But I mean, at BuzzFeed, working with Zoe Tillman, Zoe didn't have a law degree, and there were definitely times, there are aspects of the law that she has better than me. I mean, she's covered more trials than I have. It's all specialty, and particularly, I think, for the Supreme Court, because everything is appellate, and so many of the things are either about either what the Constitution means or how a specific statute is interpreted. It really is something that, like, yeah, if you're looking at like the entire Supreme Court term, like, yeah, that can be a little overwhelming. but like that is whether you have a law degree or not. But the truth is, every case, any case that you're covering, like just when you get through the briefs, like you're gonna have a good idea of what's going on. And that's really the goal. And then being able to understand, like as Christian talked about, like how it affects ordinary people, being able to understand how you explain it to people so that it makes sense. All of those things are what matter, and those are not skills that you're going to learn in law school. So that's what I've got.
All right. Well, I want to thank all four of you for taking the time to come talk with us and for letting us go a little bit long to get those last questions in. It's been a very informative and helpful session. So thanks to the four of you, Lydia, Todd, Christian, and Chris. Thank you very much. Fellows, this is it for this morning. We have our happy hour tonight at 6 o'clock. I'm hoping to see a bunch of you. It'll be nice to actually be in the same room with you all. So have a good afternoon writing whatever stories you got to write this afternoon. And I hope to see a lot of you at 6 o'clock tonight. And my panelists, once again, thank you very much.
I know for all of us, we're all on Twitter, and if you have any questions, I rarely say that I can speak for others, but knowing these these three, like you can definitely reach out to any of us. We are the nice ones. So
Absolutely.
as whoever had said that earlier. So please do reach out to us if you're covering the court and have a question or want to get coffee or whatever. So
My DMs are open. So yeah, please add me on Twitter and ask away. So I'm always happy to help.
All right. Thanks much, guys. Fellows, see you tonight. Have a good afternoon.